All right, ladies and gentlemen, welcome to another episode of Keep It Legal. We have attorney Brooklynn Morris with us here today. Her interview was so nice, they had to bring her back twice. Brooklyn, thank you for being on the show. How are we feeling today?
Feeling good. Good to see you.
Yes. Also, want to let the audience know that keep it legal. We will be doing another segment called Off the Record, and Attorney Morris will be joining us on that episode. We will also have Ashley Venezuela on there as well, talking about entertainment contracts, NIL deals, and other forms of personal advocacy. So today we are going to talk about negligence, the elements of negligence. What happens when you get into an accident? What happens during the course of negotiation, mediation, and ultimately, if you're cooked, you're in court. You definitely don't want to see Brooklyn on the other side of the V, as we say. So, Brooklyn, why don't we get started with mediation negotiations? We have an accident, and now where do we stand?
So before you would get to a mediation setting, there would have been some type of a claim filed. Normally, your typical accident cases are motor vehicles or a slip and fall, if you will, to where a claim was filed immediately after. And then after that claim was filed, you try to work with what we call adjusters who handles claims, and they try to look at what happened, look at the police report, gather your recorded statement. And for some reason, maybe you didn't get the desired outcome in that. Maybe they felt like they weren't at fault, um, and you don't agree with them. In that event, sometimes, oftentimes, people go it alone, or they hire an attorney to help try to settle that, what we call that claim. And this is all pre-suit. And then you get to the point where if you hire that attorney then looks at the elements that are in play here with regard to a personal injury claim and those elements of negligence. And that rule typically involves proving four elements of the law, and that is your duty of care, whether the defendant owed a legal duty to the plaintiff or the claimant, what we call them. Then you look at the second element, which is a breach of that duty, and that is whether or not the defendant breached that duty by acting or failing to act in a certain way. And then you have that third element, which is causation. You also will hear proximate cause, but the blanket term is causation, in that you have two types of causations that it breaks down to. It has some tentacles to that element. You have what's called actual causation, which means that the harm wouldn't have occurred but for the defendant's actions or that adverse driver's actions. Like I wouldn't have been rear-ended but for the adverse driver not paying attention, following too closely, and eventually rear-ending me. And then you have something that's called proximate cause. And that is also a legal term where it's saying the harm was foreseeable. It was a foreseeable result of the breach, which was that element two, meaning you could foresee someone being rear-ended in a certain set of circumstances. And then you have what's called damages. And damages is, what did the plaintiff suffer in terms of harm? Was it physical? Was it emotional? Financial?
Yeah, a lot of times we hear people say that, oh, the law is broken or there's a problem with the system. And as you so eloquently put it, it's really in the hands of people. So now that, as we're on the topic of mediation, we've actually surpassed that. Now we're in litigation. Now we're in your home, as I should say. I don't think too many are going to be able to compare with your skill set. So take us from mediation, negotiation is not working. Then where do we go?
Yeah, sure. So, first of all, mediation is a confidential process. It's a voluntary process, and it helps parties resolve disputes mutually without going to trial. Some attorneys don't want to go to trial. You have attorneys who are trial dogs. You have attorneys who want to settle. I could find myself enjoying both. I think not all cases deserve to go to trial. Um, and so I do think and believe in that. And it does matter in the end. So when you have that case that's ripe for mediation, you look at who's involved. You're going to have a neutral third party involved. That's called your mediator. They're going to be able to guide that discussion. Then you have an understanding that the mediator doesn't make decisions. They don't take sides, hence that's why they're a neutral party. Their job is to help both parties communicate and understand each other's positions and explore possible solutions. Some of these mediators have law licenses, most of them. And so they're able to understand the law and help you get to the point in where you want to be. They've seen the same type of cases. They've seen the value, the case value is what we call it. And they help you come up with a number that both parties can reach. But no, neither party is going to be happy when it's mediation. That it doesn't mean you're getting what you want, but you are coming to a mutual acceptable settlement. And so each party and their attorney, if represented, which I highly recommend you have an attorney in mediation, that they participate and they have the opportunity to present their perspective. And it's more of an informal, especially nowadays in 2025, a lot of mediations are Zoom. Most of mine occur via Zoom. I do have a
Mm.
sprinkle of in person, um, but it begins with joint sessions where the mediator explains the process. Both sides have you can outline your positions to a certain extent. You might not want to divulge everything in a mediation setting, and you might want to get it all out. But ultimately, the goal is to reach a settlement agreement. All the discussions are confidential, can't be used later in court if the case can't settle. And let's say if there's no settlement during mediation, but we might have gotten close, the mediator, excuse me, would normally do what's called like a proposal. And you get what they think the case should settle for. And then that's another opportunity to come back to each other and have a discussion on that number. If you reach that agreement, it's a binding settlement contract. You notify the court and you get out of there.
Um, Now that you have finished doing mediation negotiation, um, what's the next steps?
So let's say you don't come to an agreement, you don't like what the mediator is proposing, and discovery is up because, mind you, I talk going back to the claims stage. Um, if something there's a point in time if the attorney's involved that a lawsuit is going to be filed from the plaintiff side, and that opens up what's called the discovery process. And now you're notifying the court of your claim of that accident that occurred. And so you're going to try to have a scheduling order produce something agreed between both parties. And you're going to get a trial date. And when you get that trial date, that sets the clock for every other thing, including discovery, depositions, and things like that. And so if mediation that's built in that scheduling order doesn't happen, there's normally a trial within the few months after that. And so you have to prepare. You have to gather all the evidence you've been working on leading up to mediation, after mediation. You should have already probably deposed the proper parties, and you're getting all of that together, and you're getting your pretrial documents, and you're getting ready for trial.
So the word in the court is that they call you the deposer. What does that mean? What do you mean by that?
A deposer is just somebody who takes depositions. That's it. It's a self-proclaimed name. It's one of the tools that you can use in civil court, and it satisfies my love for criminal. And it's an informal setting. and you're on the record though, but it has the same force and effect as it would in trial. It's a live testimony, and it's used to impeach in a later date should you go to trial. And so, one of the ways that you also can use depositions is through trying to get to that motion for summary judgment. Um, in that you try to elicit certain testimonies on the record that goes and cuts towards their element of causation, of duty, of breach, of damages. And so I like it especially as well because a lot of the plaintiffs, they're everyday people. They have no idea about how to testify, and if you're not prepared, if your counsel doesn't prepare you, it can certainly make you look bad on the record because everything you say is being transcribed for the court. And so if you don't know the legal, parameters in which you're working with and what to say and how certain ways you say things can hurt your case, it can get really bad for you in there.
So when people are doing depositions, essentially the individual or individuals that are being deposed, they may not think that what they're saying is going to have as big of effect in court as it is currently happening as they're being deposed.
Well, initially they don't. The hope is that the attorney counsels them and preps them before they come in the deposition and try to explain to them that, hey, the testimony you're going to give is going to be used later in court if we go to trial. So if you don't know something, they counsel on you what to say when you don't know something or if you're not sure about something. And so for me, it's still you can prep someone all day, but when they get
Mhm.
into that room and they see the court reporter and the videographer there having you on camera and they see attorney across from them with a notepad and all kind of stuff out ready to talk to you, it can be intimidating and people forget their words, forget what they said, and yeah, it can get bad for a plaintiff or anybody who's not really prepared to go into that deposition.
Now, you mentioned the word prep, and you mentioned it in the same token as which you mentioned a client. Can you give the audience a bit more background on what it means to prep your client for a trial or any kind of legal proceeding?
Yeah, so prep is short for preparation. It's just like anything you do in life, whether you're at work, behind a McDonald's restaurant, whether you're IT professional or a typical business woman or man, you have to prepare for your job. You can't just show up and do what you're supposed to do and execute properly if you're not prepared. And so a lot of our job as attorneys is thinking ahead of the game. We have to be 10 steps ahead of where our client is because their job is to just relax and be ready to, you know, remember the good facts, preserve certain documents and evidence. But ultimately, we're the ones that's thinking ahead for them and counseling them on what to expect. And so when I say prep or preparation, that just means, hey, sitting them down before the actual deposition and taking them through what they can expect to be asked. If it's a employee for a particular company, they're going to be expected to be asked about the nature of their job, how long they've been at that job, the skill level they have, even a little bit of background information. And they need to be ready to, explain things about what it takes to carry out their day-to-day jobs.
Mhm.
Um, if it is a corporate representative, they have to be prepared to discuss the policies and procedures that are implemented at said company because they're going to be
Mhm.
asked about that. And so it's just prepping them for those questions, playing devil's advocate at times to try to elicit testimony. And it's also another opportunity to get the facts and get the real understanding of where our client stands.
Okay, so we have gone from the accident, the issue, proximate cause. We have our claim. We've had discovery. We've had witness preparation. We have done and we have concluded our depositions. We're at trial now. And so we have three big components of that, which is opening statements, cross examinations, examinations, and then we end on closing statements. Brooklyn, can you walk us through how all that happens?
Sure. So, with regard to opening statement, that is your storytelling time where you are telling the jury what you intend to prove. First, you always want to greet the court in your introduction. You want to introduce yourself and the client. You want to state your purpose, why you're there, because juries don't know what's going on. Like they, a lot of times it's their first time in court, especially in a, let alone a trial setting. They really are walking them down like a teacher would a student. You state your purpose, like this is what the evidence will show, and then you go down to the overview of your case. You want to briefly explain like the facts to your side. You want to tell the story clear. You want to be logical in an emotionally compelling way.
Right.
Obviously, your theft of grocery products is going to be a little bit less emotional than, a wrongful death suit, and you do
Uh,
get cases that are hilarious, and you're trying theft of thousands of dollars of merchandise and but you're still trying to invoke some type of seriousness is because this is someone stealing from the community, you know
$1,000 worth of bananas
that
or
normally
crab
would.
legs.
Yeah, well, that normally won't see the daylight of trial, but you get the
Oh,
point. And then
yeah.
then you have like the key evidence that you want to highlight. You want to highlight the main evidence or testimony that you intend to produce or show. You want to mention key witnesses that you intend to produce. You want to mention what they're going to say. And keyword will say, will show what we intend to do. You don't want to make any conclusionary statements in your opening because we're opening, we're not closing. We still haven't put on any evidence. And you have to think of trial like an empty box, right? And around that box, you have evidence, you have testimony, you have you got your jury thoughts, and you have theories. And your job is to get that evidence in the box, get everything in that box that you can. And sometimes you just can't. And based on what's in that box, that is the parameters in which juries are allowed to decide guilt versus innocent. And so it's important to let them know and tip them off on what they're going to see so that when that closing comes, they would have already known what they were looking out for. And it's definitely what you want to establish as far as negligence, since we're on the topic of negligence, you want to establish those elements. If it's assault, you want to establish those elements. What is the elements of negligence, and you have to walk them through that. You've already kind of done that in more dire. So you're just bringing it in again. So then you have the theme of the case. You want to present central ideas, justice, trust, motive, mistake. What is the theme here? Whatever hat you're wearing. If it's the defense hat, you want to think about accident, mistake, sometimes even motive. If you represent the other side, you want to think about justice, you know. And so, the conclusion of your opening then is going to look more about you restating what you're going to show, and then politely asking that jury to keep an open mind and to listen closely because people tune out. Even I tune out. And so they could be missing a very, very nuanced piece that is important. So you want to remind them, hey, I need you to listen and keep an open mind.
Mm,
Um, Especially if there's going to be some bad facts
mm,
that might not paint your client in the best light. You want to just kind of get that out in a way that doesn't, you're not saying your client is guilty, but you're saying he's human, he or she. Hey, you're going to hear some things. You might hear this, you might hear that, but I need you to understand that this is a trial process. A lot of evidence needs to be had, so just keep an open mind as we continue on. And then after that opening statement, the other side will have the opportunity to provide their opening statement, and then you have the direct questioning, which is where you're putting on your case in chief and you're directing your client to the answers and testimonies that's going to support his or her case. This is not a cross-examining. You're not being hostile, even though in certain cases you put on your own witness and you have to treat them hostile.
Why
Which
is that?
that is another story. But it's sometimes you have to put on a witness that flips on the stand and says things that what they did not anticipate on saying, and now you have to cross-examine them in order for them to bring out to tell the truth of what you put them on there for. But it's a little bit more to that as well. But
Yeah.
cross examination is kind of where you get your more aggressive style approach seen. The purpose is to discredit the witness or their testimony. The purpose is to expose any biases or lies, contradictions. The purpose is to reinforce your case theory through them, through their testimony, and undermine the other side's narrative. So those are the things I try to focus on. You lead with questions. Um, you ask questions that suggest the answer, which is usually a yes or no. A lot of times people hate answering just yes or no, which at that time you have to gather them up and make it clear that you are responding to my questions and I'm asking you in the form of a yes or no. And
Mm.
so example would be like, you didn't see the defendant's face, did you? Versus, what did you see that night? Right? That's going to
Mm.
elicit two different types of answers.
That's that's
Um,
that's that's pretty
yeah,
good. That's tough.
yeah.
And that's
So
why they call you the poser. See, that's right. That,
yeah.
ladies and gentlemen of the court. But
But you want to stay in control. You don't want the witness to explain. You want to keep them on short answers. If they try to explain, you want to interrupt them politely and restate the question. You want to be clear, you want to be simple, direct, and just avoid those open-ended questions.
we have discussed how we're in court. We have discussed open statements. We have discussed cross-examination, examination, hostile witnesses, uh, learning how to navigate and what questions to answer, what questions not to ask. And now it's all over, and we have our closing statements, closing arguments.
Okay, so now you're in closing, and like I mentioned with opening, the same way you would want to introduce yourself and greet the jury, you want to thank that jury. You want to acknowledge the time that they spent because people are leaving work. Some people can't afford to really take off work, so it truly is um, a village effort in that you're pulling people from your work. You want to recognize that, and they can appreciate that. You want to thank them for their time, their service. You want to restate that theme by reminding the jury of your case's central theme or whatever that theory is. You want to summarize that key evidence, right? Review the most compelling testimony. Go over those exhibits. You heard her deposition testimony. We brought the pleading to her deposition testimony. The pleading she said that she read and went over and reviewed and filed along with her attorney. She claimed permanent disfigurement. Do you see any permanent disfigurement today? Because now that we're in trial, now we're in front of the jury, we're no longer behind paperwork, we're no longer hiding behind medical records. You're able to see firsthand what disfigurement looks like, and that's not what that is today. Right? So you want to
That's
talk you,
hold on,
you,
time out, time out. That's tough. Let me tell you right now. If that's not your lawyer, if, uh, listen, if that's not your attorney, Gucci, you're a cook. Hey, what Future say? Ain't
Uh,
no way.
yeah.
That's good.
Right. And remind the jury, why are we all here to begin with? We could talk about this all day, but at the end of the day, if it's criminal, you got to remind them of the burden of beyond a reasonable doubt, that it is the highest burden you can meet. If it's civil, you refer them to the preponderance of evidence. I just need 51% over 50%. This is
Mm,
not criminal court, a
mm.
preponderance of evidence. And then,
And that's what I love what Brooklyn brings to Keep It Legal off the record is the ability to think sharply, think quickly, and to be able to process a lot of sometimes arduous and complex information. And you did a really good job of good fact, bad fact. You know, that's a law school term. Good fact. Hey, come on in. It's real nice. Hey, now watch out. There's a little puddle over there. Okay, but hey, it's a mansion. We can get past that. It's okay, right? Like that. That right there is masterful. And the next time we have our show, because Brooklyn will be back. She will be a regular guest on here. I guess you could say co-host, try-host. Uh, Storytelling, which obviously, as you have witnessed, so to speak, that being able to tell a narrative, which means if you want to be helpful to your attorney, you should have an idea of a narrative. Most times when you go see an attorney, they're going to say, well, give me a factual summation or give me, what happened, from A to Z. And by God, if you don't say A to Z, they got someone like Brooklyn on the other side of the court. Just she got that fryer pan, like, yep, you didn't say that. But ladies and gentlemen, we could keep going on and on. But uh, Brooklyn's time is not cheap. And we all have to, keep going. But very grateful and thankful to have Brooklyn here. We're going to be going through a lot more of the examinations, the details, the nuances. So you, as the community, can be as informed as you possibly can. And thank you so much. And remember, always keep it legal.